The state is arguing its case on why state and local law enforcement officers should be allowed to detain immigrants suspected of illegally crossing the border under SB-4.
The Fifth Circuit Court of Appeals in New Orleans heard arguments over the legal standing of Texas's Senate Bill 4 after a lower judicial court placed preliminary injunctions on the law, stopping it from taking effect. The 2023 version of this bill would grant state and local law enforcement officers the power to detain immigrants suspected of illegally crossing the border. The state of Texas, represented by the Office of Attorney General, made its case for self-preservation.
The Constitution gives a right to Texas, in this case the state self-defense clause. That right to the state, created by the federal Constitution, couldn't be infringed by federal statutes.
Following this morning's hearing, David Donacci, with the Texas chapter of the American Civil Liberties Union, talked about the fight still on their hands.
Every single court to have decided the fundamental constitutional questions has held the exact same way, that what Texas has done with SB-4 is an unconstitutional intrusion into an exclusively federal prerogative.
Donacci also pointed out what it would mean if SB-4 is allowed to go into effect, comparing it to what's happening around the country when it comes to immigration enforcement activities.
It licenses every single peace officer in the state of Texas to police not what people are doing, but who they are.
Texas is using its constitutional wartime powers through its judges. Judicial orders, Texas court orders can't themselves violate federal law.
David Donacci with the ACLU of Texas
is confident the Fifth Circuit Court of Appeals will side against SB-4 like it has in the past.